Philip Lagat, T-O-N, and I appear...
Alright, you can take a break and do that.
Morning, Your Honor.
Good morning to you.
In that matter,
Is critically aware of supposed to be released, and the fourth one is supposed to be released on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. The Constitution does not say that police may arrest a person when there is a prima facie evidence of the offense. It must, of course, require probable cause of an arrest, but not prima facie case in its technical acceptation. Now, the general rule, in my view, is for the courts to try to strike a balance between the need for a tie in mind, the circumstances surrounding each case. Thus, in determining the public good as well as the rights of the accused should be kept in mind. This is also the scenario from other jurisdictions like the Indian Supreme Court, where they say that the grant of bail, though being as a matter of order. The theft and the impersonation, and according to the investigation officer, the matter is complex and they need 7 days to obtain some vital information, and 3, to ensure that the respondent board is yet to be established. The constitutional right and Article 49(1)(h) of the Constitution is very foreigner ought to be released on bail as a matter of right, pending the hearing determination of the church. It provides, I quote, an arrested person has the right to be released on bond bail on reasonable conditions, pending a church or trial unless there are compelling reasons not to be released. In Kenya, we have the Court of Appeal, Michael Jumo Yamo, and another versus Republic. We also have R versus Joktan Malende and 3 others, where the court said the following. The phrase compelling reasons could denote reasons that are forceful and convincing as to make the court feel very strongly that the accused should not be released on bond. Bail should not therefore be denied on flimsy grounds, but on real and cogent grounds that meet the high standards set by the Constitution. Also looked at the South African case of Supreme Court South Africa in the case of Rechin and others versus S. I also looked at S versus Peterson 2008. The courts in South Africa said the phrase exceptional circumstances is not defined in the Superior Courts Act. Although guidance on the meaning of the term may be sought from case law, our courts have shown a reluctance to lay down a general rule. This is because the phrase is sufficiently flexible to be considered on a case-by-case basis, since circumstances that may be regarded as ordinary in one case may be treated as exceptional in another case. For instance, in the Peterson, a full court of the High Court South Africa, Western Cape Division, observed that in relation to an application for bail under Section 60, subsection 1 of the Criminal Procedure Code of South Africa, on the meaning and interpretation of exceptional circumstances in the context, there have been wide-ranging opinions from which it appears that it may be unwise to attempt a definition of this concept. But generally speaking, exceptional is indicative of something unusual, extraordinary, remarkable, peculiar, or simply different. Now, taking into account the reasons that were given by the investigation officer in this matter, it only relates to retrieve documents of Facebook, and also the court statements from other witnesses, and also to ensure that the respondent does not flee the jurisdiction of the court. Can this be compelling reasons in terms of what I have just set out? I need to see any input on the part of the suspect in processing this piece of evidence, like retrieving documents from Facebook account, like recording statements from other witnesses, like ensuring that it does not flee from the jurisdiction of the court. These are the processes that are purely within the purview of the investigators and do not need the participation of the suspect. Truth be told, these reasons are not compelling reasons. I'm persuaded at this stage to admit the suspect to a cash bail of 50,000 shillings and is required to appear before the DCI offices every Friday of the week till investigations are concluded. The mention will be on 24th of April 2025 to track the progress.
Nicholas,
That's good. Are you able to see them?
Fourth respondent.